The objectives of this module are to understand the debates that were carried out between the positivist H.L.A. Hart and the natural law theorist Lon Fuller. The author of this module is Garima Goswami, an independent research scholar in New Delhi. I'm Akash Singh Rathore from the Lewis University of Rome. Law and morality. As we learned in the second module, covering legal theory from Austin to Ratz, there has been a long-standing debate between legal positivists and natural law theorists. For the positivists, law is simply what is. Morality is what ought to be. And what the law is fundamentally about is a separation between what is and what ought to be. In other words, the legal system is a freestanding system of what is, and it doesn't need to point beyond itself to some other conceptions, some other moral system, theological system, or what have you, in order to justify its independent and autonomous existence and validity. Natural law theorists, however, reject this contention. They think that law is based on something beyond the legal system, and that is specifically morality. So this argument between law and morality has taken form in the legal theoretical argument between positivist legal theory and natural law theory. Now, one of the places where this contention becomes most urgent for us to solve is in a situation like the clearly unjust laws that were in place during the Nazi Holocaust in World War II. This highlights the problem, the realities of the problems between the legal positivist position and the natural law theorist. We're going to address this broad framework of argumentation between positivists and natural law theorists by two particularly brilliant legal scholars who represent these two positions. One is H.L.A. Hart. He was a legal positivist. The other is Lon Fuller. He was a natural law theorist. Now, Hart and Fuller engaged in very lengthy debates between these two traditions of jurisprudence. It began when Hart published in the Harvard Law Journal in 1958 a paper entitled Positivism and the Separation of Law and Morals. Fuller replied in the same journal with an article, Positivism and Fidelity to Law, a reply to Professor Hart. So Hart published a paper clarifying what positivism means and speaking of certain common accusations against positivism and emphasizing the separation of law and morals. Fuller replies to Professor Hart in the journal with this idea of fidelity to law. We'll get into what is meant by those in a moment. Hart consequently wrote The Concept of Law, a major book outlining legal positivism in its 20th century form. Fuller replied with another book, The Morality of Law, reinstating the need to maintain a natural law position in spite of the growing popularity of positivism. Subsequently, this debate continued through journal articles. So Hart and Fuller debated throughout the length of their lives this issue between legal positivism and natural law theory of law. Now, in his original 1958 paper, Hart addresses three common critiques usually leveled by natural law theorists to legal positivism. The first was basically a problem that's commonly addressed to legal positivists, which is that the Austinian theory of law as command is completely inadequate. In other words, John Austin, one of the first great positivists and student of the utilitarian philosopher Jeremy Bentham, proposed legal positivism in the sense that he gave a definition of law that was completely self-standing. His definition of law suggested that law is a command issued by the sovereign with a threat of sanction or punishment, which people are generally obedient to. So through these four concepts, Law as command, so the command concept, that is issued by the sovereign, so the sovereignty or authority concept, that is backed by a threat of sanction, so the punishment concept, and to which people are generally obedient, so the obedience concept, that these four concepts permitted us to understand law and the entire legal system as completely free-floating. There's no need for morality, and as you can see in this definition of law as command, there's not even any scope for morality. Where does morality fit in? You have a command, you have a sovereign who issues that command, you have the punishment he metes out if you break that command, and people are generally obedient to that command. We don't need God, we don't need morality, we don't need anything else beyond the legal system to understand the nature of law. The second accusation that's often leveled against the positivists is called the problem of penumbra. Now, penumbra refers to some sort of looming or shadow. Umbra is Latin for a shadow or a cloud. So the penumbra is this sort of looming problem. Now, what this refers to is that occasionally when attempting to determine the meaning of a word within a law, the established meaning, the dictionary definition, for example, seems completely obsolete or inadequate to cover what the considerations are. So a judge interprets what it must mean. Now this raises the question of, aren't judges deciding what is by what ought to be? So this is the kind of accusation that a natural law theorist might pose to a legal positivist, that the legal positive position is to separate law, what is, from morality, what ought to be. And yet, the problem of the penumbra shows clearly that even positivist judges are deciding what is by what ought to be. In other words, they're deciding what this law must mean, because it's not in itself clear, by what it ought to mean. Hart suggests that this second problem that natural law theorists accuse positivists from succumbing to is actually easily solved, considering that what ought to be is not understood as in a moral sense. Rather, it's understood within a rational legal framework. So what ought to be read into this law is not appealing outside of the law, but rather appealing to the internal consistency of law. The positivists face a third challenge, which is morally bad law. As we had mentioned, the most striking example is the legal regime of the Third Reich, or the German Nazi regime. So these were a set of internally consistent, possibly, morally bad laws. So the legal positivists have a deep and serious challenge leveled against them by natural law theorists, saying that you have to have a higher principle behind the legal system, otherwise you have no way of condemning a legal system such as the Nazi regime, which committed so many crimes against humanity. So these three arguments that Hart articulates in his original article are the substance which Hart and Fuller will ultimately debate. For example, in Fuller's reply to Hart, he says that he is unconvinced by the argumentation that Hart puts forward in terms of justifying law as command, in terms of the problem of the penumbra, and in terms of solving the problem of morally bad law. Hart says that he defends a minimum content theory of natural law. In other words, in order to overcome the problem of morally bad laws, Hart will allow a certain influence of morality within the legal system. But he refers to this as an absolute minimum. In other words, only so much moral infiltration as is necessary to maintain the internal consistency of the legal system. In the earlier module covering Austin to Ratz, that's module 2, we discussed different kinds of positivism in terms of inclusionary positivism, which allows the inclusion of a certain amount of morality into the legal system, and exclusionary positivism, which allows absolutely no moral considerations in the system of law. Law is what is, morality is what ought to be, and the legal system is fundamentally about what is. That exclusionary positivist position is represented by the juridical philosopher Joseph Ratz. But here we find that Hart offers some sort of steps towards an inclusionary positivist system. Now Fuller, on the other hand, the natural law theorist, is unclear about whether for Hart, the positivist who is willing to include a little bit of moral considerations, whether for Hart the distinction between what is and ought to be really is about morality. In other words, Hart says what ought to be, if it's understood from the natural law position, is an attempt to preserve a precious moral principle. Now Fuller is saying that what ought to be, according to natural law, is not about preserving a precious moral principle, it's about preserving fidelity to the law itself. In other words, Fuller is suggesting that legal positivists are moralizing the nature of morality, when in fact the moral input into the legal system is already there in positivists when we see that the attempt to internally reconcile all legal principles is seen as a value, fidelity to the law. That value is the value outside of the legal system to which the legal system necessarily references. Let me try to restate that in a way that we approach it from another angle. The positivists have said that the legal system is free-floating and self-standing, and when we decide what ought to be, we're only deciding what ought to be from within the framework of the legal system. So there's no appeal to anything beyond the legal system. Fuller, on the contrary, says that this doctrine of fidelity to the law that makes you want to make the law internally consistent is not something that comes out of the law itself. It's something that you appeal to make the law consistent. So the very notion of fidelity to law is beyond the law. It's an idea that is second order. You step back from the legal system and say that the legal system ought to have fidelity and clarity and non-contradiction. And Fuller's position is that is the very content of morality in legal positivism, which legal positivists don't recognize and instead accuse natural law theorists of being concerned about precious morals. So Fuller suggests that the legal positivists create a straw man saying that the morality that natural law theorists think of is some sort of precious moral principle. Fuller's argument is not at all. The very fidelity to law that positivists claim is internal to law is actually that moral source external to law that informs the legal system. Moreover, in Fuller's response to Hart, Fuller makes a distinction between external morality and internal morality. So external morality can be conceived of as a moral suggestion that one must follow the law. So the conflation of legality and morality. So some people conflate what the law is for what morality requires. But it's clear that everything that is moral is not legislated, and everything that appears in law has nothing to do with morality. For example, a law might be in place simply for safety to the person conceived in purely medical terms, not in terms of moral terms. Or a law might be put in place just to implement certain standards that are required for maintaining quality, or some other amoral consideration. So the overlap between law and morality is not at all clear. So to think that when natural law theorists are speaking about the relationship of law and morality, it's some sort of external sense of morality, as though to be legal is to be moral, or in order to be moral you must be legal. This is not at all what is necessarily meant by the natural law position linking law and morality. Rather, it is an internal morality that we're talking about. We can also refer to it as conscience. So Fuller believes that Hart is actually aware of this internal morality. He refers to it as justice in the administration of laws. So legal positivists also have a sense of certain mandatory concerns about justice. Sometimes these are referred to as the principle of natural justice. We discussed that in another module on natural justice. Now, positivists accept principles of natural justice. Think, for example, that one should not be both the judge and the defendant in his own case. This violates natural justice. So we could never permit that within law, even conceived as positivistic. Or another principle of natural justice, that both parties to a case must be heard. We don't tolerate it as being just if a judge listens to the accused but doesn't listen to the victim, or if the judge listens to the victim and refuses to listen to the person who is accused. Both parties must be heard for us to have any sense that justice has been done. Now, this principle of natural justice is accepted by legal positivists, and Fuller argues that this is a backdoor entry of morality into legal positivism. Now let's look at the problem of penumbra, this is-ought distinction. There's a clear example here that Hart himself uses. The law states vehicles are not permitted in a park. Now, someone has taken his bicycle into a park and a policeman writes him a ticket because violating the law that vehicles are not permitted in the park. Well, what does this term vehicles mean? Well, clearly, we go from what is, the definition of vehicle, to what ought to be. Bicycle ought not to be included in the definition of vehicle. Why not? Because the law must have been referring to motorized vehicles, not polluting the atmosphere of the park and so on. So a judge understands the nature of what is in the law according to the reasons behind it or what it must be appealing to. Fuller states this is a matter of seeing the correlation of what ought to be in what is. But as I had already suggested, Hart said, no, not at all. This is just an internal process of what ought to be based on the categorization and harmonization of the total system of laws. The problem of penumbra remains as one of the principal issues of debate between legal positivists and natural law theorists on whether the law is what is or also what ought to be. Now we move to another issue of contention, the relationship of law and morality in terms of morally bad laws. In this we turn to another case which is referred to as the informer case. In this case, a wife had informed the authorities, namely the Nazis, of her husband's insult against the leader Hitler. There was a law in place that stated that anyone who should insult the Führer, the leader, Hitler, would be subject to criminal prosecution. Now, a woman informed the Nazi party, the stormtroopers as they're referred to, the SS, that her husband at home would insult Hitler. The stormtroopers came, they took the husband away, and ultimately he faced death. After the war, after the Nazi regime was dismantled and the Allied victory, there were many trials that went on to convict these Nazis of war crimes, of crimes against humanity, such as the Nuremberg trial, or later the trial against Adolf Eichmann, who was responsible for shipping the Jews to their death in Auschwitz and the other death camps. There were also trials related to such crimes such as this. So this woman wasn't a Nazi functionary, she wasn't an SS member or anything of that sort. She was just a civilian who had implemented the law. Now, the question is, should she be punished? Well, what would a positivist say? She was following the law. The law is what is. It's not her business about whether it ought to be what it is. The law is a command issued by the sovereign under threat of sanction, to which she was obedient. The natural laws theorist, on the other hand, argues that she ought not to have implemented that law because that law violates every principle of our conscience, our internal morality. And there's no reason for her to run off to tell the Nazis that her husband at home is merely criticizing Hitler. Now, during the trial, the verdict that was given by the Allied judges was that the statute under which the wife claimed protection was contrary to sound conscience and all sense of justice for any decent human being. So, she could not claim protection that I was just following the law. This was the decision that was meted out, and she was punished. She was punished because she followed the law. Now, this is impossible to conceive of under a purely positivistic regime. In natural law theory, it's very easy to see there was a bad law, a morally bad law, not a legally bad one. It might have been consistent with the entire legal system, but there was a morally bad law. This woman was bound by something beyond the law, her internal morality, to not report on her husband. She chose to report on her husband, and therefore she violated not the law, but the basic principles of human conscience, and she should be punished. Now, similar reasoning was decided in many other cases, in the Nuremberg laws, in the trial of Adolf Eichmann. So what all of this post-World War II jurisprudence seemed to show was the triumph or the victory of natural law over legal positivism. So here we've discussed the problem of penumbra, we've discussed the problem of morally bad law. Now what about the critiques of the command theory that are leveled against legal positivism? Well, H.L.A. Hart inaugurated a system of making positivism more, in some way more nuanced than Austin's command theory. Now, Austin's command theory was that law is a command issued by the sovereign with the threat of sanction to which people are obedient. But is that really how every law is? There are numerous kinds of administrative laws, numerous kinds of civil and family laws that have nothing to do with that framework of the definition of law that Austin put forward. So Hart begins to address this problem by inaugurating a distinction between primary and secondary rules. The primary rules are the ones that more fit into the Austinian sense. The secondary rules have to do with the operation of the primary rules. They include rules of recognition, rules of change, rules of adjudication, all kinds of other administrative rules that certainly bind public officials, but aren't necessarily those that bind the citizens and all the body politic. So in nuancing the theory of the command theory of law, Hart serves to rescue the basic principles of positivism from the critique that the definition of law in positivism is empirically inaccurate. So we've seen Hart's position on how to address problems of command, how to address the problems of penumbra, and how to address the problems of morality in law. What we've noticed is, while the first two are fairly successful within legal positivism, the third one, on the distinction between morality and law and how to deal with morally bad law, does pose a deep problem to legal positivism. And it almost seems that the Second World War and the jurisprudence coming out from the Second World War seems to favor natural law theories. But we should keep in mind that in legal reasoning, it is not as pure and distinct a separation of theory as you find in for example, moral philosophy or epistemology or other subjects of philosophy. While in epistemology, we would assume that either you are skeptical of knowledge or you are optimistic about knowledge, but you can't be both. In moral philosophy, either you are deontological and principle-based or utilitarian and consequence-based, but you can't be both. Legal reasoning, however, freely participates in various sorts of deliberative methods. So we might choose to adopt both a deontological and a consequentialist approach. This is clear, for example, in believing that all human beings are fundamentally endowed with a dignity that is inalienable, and yet, in the same legal system, permits something like the death penalty. So legal reasoning participates of more fluidity in approach than other forms of philosophy like epistemology or moral philosophy. And just so, it is possible to have a broad framework adhering to legal positivism that introduces elements of appeal to natural justice or natural law when it is necessary. So several positivists or people interpreting the nature of these theories suggests that for the most part positivism holds. But in extreme circumstances, like Hitler's regime was certainly an extreme, then ultimately appeals to something beyond naturally bleed into the nature of jurisprudence. Well, Hart's suggestion then might be some sort of inclusive positivism, but Fuller suggests this is nowhere near adequate. Far from accepting merely inclusivist positivism, Fuller argues that positivism is all wrong and natural law theory is correct. So, in the understanding of law and morality, it is not just certain extreme cases where we understand that influence, but every moment, every day of law is pointing beyond itself to moral considerations. For Fuller, there are 8 particular principles that make up the inner morality of law as such. Again, not just law in certain circumstances, but law as such. And this is his procedural version of natural law. What are these 8 principles? Law must be existent, not ad hoc. In other words, we can't say, don't you know that that's the law, and make it up in the process, right? The law should already be there. Law must be promulgated. On the one hand, we've all heard that ignorance of the law is no excuse, but that can only be true if the law is widely promulgated. How could I be anything but ignorant of the law if what the law is not widely publicized? Number 3, law must be prospective rather than retrospective. In other words, lawmakers, when they establish law, it stands from that moment onwards. It doesn't say all of those who did violate what we're saying now is the law over the last 30 years must go to jail. That doesn't make any sense at all. Law must be prospective. 4th, law must be clearly stated and comprehensive. In other words, it needs to make sense both in itself and in relation to the broader system of laws. Let's imagine that I have a speed limit posted here of 80 kilometers and I'm traveling along, and the next speed limit posted without any warning, without any bumps in the road or whatever, the next speed limit posted is 10 kilometers per hour. And then a policeman is standing there and says, don't you see that the speed limit is 10 kilometers per hour, and writes you a ticket. This makes no sense at all. It's not comprehensive. This is a kind of lack of systematicity that no citizen could be expected to follow through with. 5, the various aspects of the law must be consistent with each other. So family law should generally be consistent with criminal law. You shouldn't allow things of customary practice within one domain of law that you forbid in another domain of law. So obviously, even if it is a practice within a certain, let's say, animist religion, to which we generally give autonomy to engage in human sacrifice, Since murder violates criminal law, we're going to have to harmonize, make consistent both criminal law and family law in this respect. 6, the law must be possible to be obeyed. If it's not even possible to obey the law, then how can you accuse someone and punish someone for its violation? 7, law must be constant or relatively long-lasting. In other words, it shouldn't just be in effect for a brief period and then not in effect, and then come into effect again. This makes it difficult to do number 6, which is to obey that law. We never know when it's implemented and when it's not. And finally, it must be, and this is his 8th principle, it must be applied and administered as stated. So this puts an obligation on those who administer the law, in India, for example, the IAS or the IPS, to administer that law as it was decided by Parliament. So acts, when they become rules, those rules must be consistent with the acts. Now, all of these principles would seem to be acceptable to positivists, at least prima facie. On the face of it, these seem to be the basic principles that we understand by natural justice. Obviously, for a law to be valid, it must be possible to obey it. Obviously, for a law to be implemented, it must be implemented in the way that it was meant. Obviously, the law should be prospective and not criminalize activity before it was even a crime. These are just standard ways of thinking procedurally about the law. Fuller's argument is that these are all clearly based on an internal moral sense, that it is morally wrong to condemn people unheard. It is morally wrong to expect people to follow a law that they cannot possibly follow. It's morally wrong to apply a law in a different way from how it was originally conceived. It's morally wrong to put a person in prison for a law that he had no idea existed since it wasn't promulgated, and so on. So this is the infusion of the legal process with morality from the point of view of Fuller's natural law theory. So let's start to sum up then. For Fuller, law must serve a purpose. Its legal system is not some free-floating thing. It points to some higher purpose, which is to achieve social order by subjecting the system of law to moral scrutiny, to moral rules. Failure to comply by these principles will certainly make laws invalid. In other words, in the case of the informant, that law was in itself invalid because it didn't conform to anyone's moral conscience, that if you should just utter words against the sovereign, you should be put to death. That's unacceptable by natural law, clearly, because it violates your principles of conscience and internal morality. Legal positivists have a bit more problem there. Fuller seems to claim that Hart's minimum content of morality that I had mentioned in his inclusory positivism, in terms of the debate between Hart and Fuller specifically, is the ground for some sort of unity between the two positions. So Hart says that I will allow some basic minimum element of morality to creep in. Fuller's position is, now this debate is a real debate because we share some common ground. This common ground establishes some of the common ground for the way in which this debate continues to rage on. In fact, the debate is very much still viable. It's very much still occupying a great deal of legal scholarship and legal writing and research. In fact, in a recent book entitled Jurisprudence by the legal theorist and judge D'Amato suggests that the Hart-Fuller debate, the controversy, will have to be reconciled not only in legal philosophy, but in moral philosophy too. So this debate has both future ramifications in legal theory, but it also spills over into moral philosophy. And as far as the contemporary ramifications of the debate that was started between Hart and Fuller in the 1950s, we have seen already in Module 2 that this debate has continued into the 21st century as that debate between Dworkin and Ratz. Joseph Ratz as the exclusionary legal positivist and Dworkin, who insists on the introduction of clear elements of morality in the legal system. Thank you.